How are you?
Pardon?
Yes, give me a moment. Let me grab the file. This is 231116LT. This is Kirkridge Park Cooperative versus Joyce Frierson. May I have your appearances, please?
Good morning, Your Honor. Julie Crota, P39367, on behalf of the plaintiff.
Ma'am, state your name for the record.
Now, are you talking to who?
I'm talking to you.
Oh, thank you. My name is Joyce Frierson. I live at 8105 Kirkridge Street, Park, Co-op, Belleville, Michigan, 48111. The case number is 231116.
No, ma'am. Ma'am.
Okay. All right,
Ma'am.
I'm listening.
This is Judge Martin.
you hear-
When we were here on April 12th, 2023, you had technology issues. At that time, you asked for time to get an attorney. We talked about it in depth about what needed to happen between April 12th and today. Today being April the 28th, I was crystal clear in describing to the parties that they would appear in person because of your technology issues. I heard you speaking to my secretary earlier and telling her that you called someone yesterday and got Zoom ID information. Today is the day and time for an in-person trial. And not only are you not physically in the courthouse that we talked about 2 weeks ago, you're on the phone, which means that there aren't documents to share. So unless you have an agreement that the parties are placing on the record.
Your Honor, I think it's possible we could have.
Could and do you? There's two different
We
things.
do not.
Okay.
But if I could chat with her for a moment, I don't know if that's possible. The thing is, Your Honor, she sent an offer to our office late last night. Of course, I was in another hearing. I couldn't call her back. And she said that she would agree to the amount of $2,259 being due. And that is extremely close to what I am authorized to settle for. If I remove her late charges, it brings her amount due down to $2,284, Your Honor, which is basically $25 more than she wanted. And then I am also authorized to waive her late fees and her legal fees as a one-time offer and only collect the court charges, what it actually cost us to come into court, the legal allowable collectible items, which total $164.
Ms. Frierson, were you able to hear that?
Just slightly. I heard something about dismissing the late fee. I heard an amount, but I'm not quite sure of the amount.
So the total amount would be $2,448 if she would like to sign a consent.
$2,448.
Okay. Now, here's the situation. I mailed them a check for $2,284. I also submitted a check for $571. What does that amount adds up to?
Ms. Frierson, we had this problem before, and I'll
Well,
ask you the same questions. Hold on. No, no, no. I'll ask you the
I'm not
same questions
speaking,
I
I'm
asked you
listening.
last time. No,
Uh-huh.
you're not, because you're talking. If you're talking, you're not listening. The
Well,
last
I'm
time we
listening.
were here, you started by saying you mailed $571. I asked you 3 separate times when you mailed it, what date. You would not give me a date. Finally, after some more conversation, Ms. Lett confirmed that she had received the check. And first she said the day before, and then she said the morning of the hearing. So the 571 was outstanding. So my question to the attorney would be, has the 571 been taken into account for the settlement amount? Now you've just said that you mailed $2,284, which is the cashier's check that you referenced at our April 12th hearing. When did you mail $2,284?
On April the 18th, 2023.
And is that taken into account with the settlement offer?
Your Honor, the $571 has been credited. I don't see a check for 2,000, except I think that Your Honor, let me add these totals. I believe that it was credited to multiple different,
Do you have JIS on in here?
$2,184. Is that the amount she's questioning?
2284.
I have 2184 that went for her carrying charges on July 1st, August 1st, September 1st, and October 1st of 2022. So they credited that for check 1061. It looks like that was where that $2,000 went. And she was down to a zero balance in October of 2022. And the rest of this came after that.
So it's not
You're
making
talking about
sense.
2022, and she's talking about a check that was mailed 10 days ago? Or you're applying it to 2022 charges?
Oh, I'm sorry. That's the only $2,000 payment I have from her. If she mailed something recently, we don't have it.
She just said
You
she
know
mailed
what?
it on the
She's not
18th
making
of this
sense.
month.
I apologize, Your Honor. I didn't hear her say that. I'm looking at where our credits are, without looking at something in front of me, I'm trying to piece it together. I have nothing from 2023, Your Honor.
Ms. Frierson, you have made this infinitely more difficult. One of the reasons why I asked for you to come in person was because of the documents that would need to be shown and exchanged. You are on the phone, which means you can't even show this court proof of a certified mailing of a check, a copy of the check, your bank statement showing that the check has been negotiated. None of what we need to have a
Okay, let
trial
me
in this
just,
matter. No,
let me
ma'am,
just,
that being the case,
okay, just let me talk after you. I don't know when you come in and when you stop. So
if you
I'm
were
being
here in person, you
respectable.
would know that because you would see my
I'm not
mouth moving.
feeling well. I'm not feeling well. I was given permission to use the phone line. I did mail them a check. She has a letter and the check was mailed to Kirkridge. So I can give you the cashier's number. The check was mailed to Kirkridge, $2,284. Now, you asked the question, Judge. You said that $571, has it been applied? She couldn't come up with a solid answer. Now, I'm going to say this. I mailed Patuk, the attorney, the people, for the people. I asked him about the membership. I asked him about different things that they must do. So he was supposed to sign something as an agreement. I mailed that check to him. They supposed to give me credit for the 571 for April's payment. The $2,284 was mailed to Kirkridge. They have the information. They have the cashier's check. And the total amount.
Show me proof, ma'am. Show me proof that they have the cashier's check.
Well, ask her. Just ask whoever's representing. Do they show a cashier's check or Xerox copy of the cashier's check?
She just
Ask
said
her
no.
that.
She said no before you
Oh
started
my.
screaming over me.
Okay, can you hold for a
So
moment?
show
I
me,
think I can. I'm going to. I'm
show
going
me, show
to.
me the proof.
Okay, I'm going to get the stub.
Yeah,
Hold on.
I need to find out from the civil department why somebody would tell her to come by phone to it.
It's going to take me just a few minutes, but I'm going to get the stub.
She said she talked to Jack.
Ma'am, I have the cashier check, and I do have the number and where it was taken out at, and I did mail it to Kirkridge. Hello?
Ma'am, this is the time where I would typically swear the parties in and take evidence. Evidence would
Well,
be, I don't know, a signed, hold on, a signed green card, a signed receipt acknowledging receipt of the check, or proof from you that the check had been negotiated. But because you have absented yourself from these proceedings, and
I'm not feeling well.
the attorney has already indicated on the record that she shows no receipt of $2,284. That means there is a
Did she
dispute
ask
as to the
Kirkridge?
balance. Ma'am,
Uh,
if you interrupt me one more time, I'm just gonna mute you. So please let me finish talking, and when I'm done, if you have a response, you can give the response. But
All
the
right,
attorney
Judge,
saying we
I'll
don't,
listen.
the attorney saying we don't have it, and you saying yes, you do, is not proof. It's not, it doesn't move us any closer towards resolution. This is not going to work. So what I will do, since you say you're not feeling well, I will adjourn the trial May 17th at 2 p.m. in person. If you are not physically in this building, you need to be at a device that allows you to be able to be seen, that allows you to be able to share pictures or proof of what you're saying. That also
Okay.
gives the parties time to exchange information. If you have proof that there's $2,284 unaccounted for, the attorney's phone number appears on the notice to appear. It appears on the summons and complaint. You've been at Kirkridge for a long time. You know how to be in communication with that office. This does not work for me. I will have a conversation with the civil department about telling people that they can come by phone when this is an in-person trial where documents have to be exchanged and the parties need to be able to see each other and see the paperwork that is at play. I said the day without even looking at you. My apologies. May 17th at 2 p.m.
Yes, Your Honor.
in person. If something changes, there is a way to execute paperwork and get it to the court and get off of the court's docket. But you saying, interrupting me and saying, yes, they have it when she's already said, no, they don't, it doesn't work. Ms. Frierson, what is it that you wanted to say?
I wanted to say this, Judge. The amount that they're giving is incorrect. The total amount comes to $2,855 that I have already given them. But I agree with you, Judge, that I should present all this pictures and everything, memberships and agreement we have to reach. So I didn't know whether I should submit it to you, all the certified information that I gave to Patuk. He's got my pictures, and I want those pictures back. He's got
I'm
the
sorry,
certified letter.
ma'am, who has your
Okay.
pictures?
Patuk, the attorney Patuk. I sent him certified letters and pictures. I sent them that he signed an agreement because they got dogs in the office, that I'm afraid to go there. I said, we got to reach some kind of agreement. I'm a member of Kirkridge. I'm totally at odds with this, the way they're treating me. So yes, I'll be there on May the 17th, and pray to God that I can get there without this feeling that I'm feeling. I'm not feeling well. That's why I called. But Kirkridge Patook, Attorney Patook, has all the letters, the agreement, and all we need to do is sign it. And whoever's sitting there saying she represents Patook, then they're apparently not doing the job.
Ms. Frierson, what I
Yes,
said to you
ma'am.
was live here in this building or with a device that allows you to see, be seen, and share information. I do not
Okay.
make, as a rule, in courtroom number one, I do not make people come who are either A, uncomfortable to physically come into the courtroom, or B, unable to come. There is technology available to you. But I looked at the notes from yesterday and it does not say Ms. Frierson is unwell and unable to appear, because I would have just adjourned the matter. I would have called the attorney's office so she knew not to appear this morning with her client. It is a matter of courtesy. So if we get to be May 17th and you are physically unable to appear, and you know that a day or two before, you should either get your device working or reach back out to the staff and tell them why you physically cannot be here or electronically, technologically cannot connect to the courthouse. That's
Okay,
all.
I
Because
understand.
if you came and the attorney wasn't here, I'd be just as I would have the same conversation with the attorney for being discourteous to you. It is discourteous when someone comes and is prepared to resolve a case through trial or conversations toward settlement, and you absent yourself of the process. You have no way to show either myself or the attorney that there is this check. You're talking about a dog in the office and letters that you sent to the attorney's office. This is a non-payment of rent case, and either the rent was paid and the charges were paid or they weren't. It's just a matter of showing the proof. And this is the exact conversation we had last time about showing the proof,
Okay.
because you told me last time that you had the certified check and then you mailed it, although you knew that this matter was outstanding and the issue of mailing and receiving of payments was outstanding.
Okay. And I understand what you're saying. I truly do. But let me just say this. In order, you have to understand the full side of this. Now, this could go into a civil lawsuit. I'm just saying this, Judge, to you. If I can't go over there and put a payment in the box because they got a dog in the unit, then I have to pay $3, $4 to certify information. So I'm asking for an agreement to be reached on that account, because I'm not going to keep on paying $4.78 because I scared they got a dog in the office. Now, I wrote pictures to show I'm a member. They're telling me, is this a member's case or is this a landlord's case? I'm saying, hey, 27 years. Now she goes back and says July. Let me tell you something. 3 payments, and she said it began in November. But she doesn't even have her act together. She's making up a lot of confusion, and I don't want to sign no documents of confusion.
Ms. Frierson, as an owner of a 100-pound dog, I understand people being scared to come somewhere where a dog is if they're not a dog person. And that is why I'm saying what I'm saying for the last time, and then I'll conclude this matter. May 17th at 2 p.m. in person or on technology that allows you to see, be seen, and share documents.
Okay.
And if you're
and I
unable,
agree with
and
you.
if you're unable to do either of those two things, you must contact the court beforehand, not 5 minutes before the case is called, beforehand, and let us know so that we can make accommodations. And the attorney might want to appear virtually as well. So let's
I
be
would
courteous to each
prefer,
other and mindful of each other.
Your Honor,
right, and I will agree with you. I'm tired of him
She can't
sending
hear you.
his representatives. I want the attorney to say, yes, I have all the documents, and he might even have the check. I'm at odds with this, and they're going to make me pay the court costs. I'm saying give it to you and let you see that I'm sent certified letters in. I'm sent checks in. I'm calculated. And I said, wait a minute. She says certain things. She doesn't have her act together. So I'm saying if I have to get an attorney to sit beside me, I'm going after them. So that's what I'm saying, Judge. And I'm not angry, just the fact that, yes,
ma'am, I'm sorry.
go ahead.
The attorney's trying to talk, but because you can't see, you can't. Step closer to the
Okay.
microphone so she's able to hear
Our
you.
client present is a Kyra. I know that she said that she's afraid to go into the office, but what I did mention with her is I said, if she comes into the office, can you go over the ledger with her? So if Ms. Frierson does have the check that she can present in person, so we know we got it, or if she has questions about what was applied to what, since Kyra is here today and knows the whole situation, she's willing to meet with her in the office.
Are you able to hear that, Ms. Frierson?
I heard a little bit, but let me just say this. I want Patuk, the attorney Patuk, because I asked for an audit because they're telling me, I don't know if I'm to mail this. Let me just say this. That $571, I don't know whether it went to the landlord or it went to the membership. I'm so confused. So I'm saying if we reach an agreement, I want attorney Patuk. I do not want that girl to sit there and say, let's reach back to July. I paid my bills for 27 years with no problem. So I'm asking for an agreement. I got pictures. I'm asking for my pictures back. And I know this is a landlord dispute for non-payment. Well, let me tell you something. 27 years I am paid them sequence in order. So somehow they're hiding payment.
Ms. Frierson, what the attorney just said is that a Kyra is available to you if you want to come into the office and go over the ledger, the payments that have been made, so you can see how they've been posted, whether it's the 571 or the 2284. And if you have proof of the 2284, that's something you should bring when you go over the ledger with a Kyra, if that's what you want to do before May 17th.
Okay. Now, could I just ask you a personal question? Cairo is for the landlord. This other party is for the members. I'm a member. So I don't know if she's going to shove down that landlord or the membership. So I don't know what books they're keeping. That's why I'm saying, let's do an audit. If I'm paying a landlord and then they're saying, no, we're deducting something, or I pay this, or they took it from this bank, I'm confused. So I want someone that other to let me know, am I the member paying membership fees or am I paying a landlord? Makes sense, because one of them works for the landlord and the other one may be for the membership.
Ms. Frierson, if you do not want to go in and speak to a Kyra before we're back here on May 17th, that's your absolute right. But on that day, at that time, the court will review the membership agreement, will review the accounting, will review any canceled checks or certified check carbons that you have, or whatever it is that you want to review, will take up on that day. Anything else on behalf of Kirkridge?
Nothing more.
Anything else, Ms. Frierson?
I appreciate that you're hearing me. I'm not feeling well. I do agree. I want to bring all the evidence and I want the judge to take a look at it. I want to make sure that I'm not overpaying, which I believe I have overpaid, and they should be responsible for the court fee.
Absolutely. Anything else, ma'am?
That's it. Thank you, ma'am, for listening.
I'll see you on May 17th. Thank you.
Okay. Mm-hmm.